Welcome to Pro Bono's webinar, commemorating the World AIDS Day. My name's Marco, and I'm going to be your host for this morning. The objective of this webinar is to galvanize legal practitioners to undertake pro bono work in the respect of HIV and AIDS. So the event is hosted by probono.org, and we have the CEO Teresa Yates joining us, and Alice Brown, a project manager at probono.org. As well, who's joining us are our two guest speakers, Candice Pillay from Lawtons Africa and Nikki Stein from Group 621. Before we begin the event, I would like just to go through some formalities for the viewers, particularly watching on the live stream through YouTube. If you have any questions, please throw your questions in the comment section below the live stream video, or use the live chat facility that is available. I will try my best to jot down any questions that are coming through, and I'll ask these later in the Q&A session at the second half of this webinar. There will be recordings of this event posted later on YouTube and Pro Bono's websites, which the details I will be posting via your registered email addresses that you've used in the form. So what's on for today's agenda? So Teresa will give us a short introduction to probono.org and the projects that they are involved with. Candice and Nikki will give us a presentation respectively around HIV, AIDS and the law. This will be followed by a Q&A session. And at the end, Alice will give a short vote of thanks, and I will close off with a short overview of how one can access the resources that are available on Pro Bono.org site that will help legal practitioners with their matters. So without further ado, I'm going to hand over to Teresa to give us a quick introduction to Pro Bono. Teresa?
Okay, thank you, Marco. Good morning, everyone. And Pro Bono is happy to be hosting this and supporting this webinar to raise awareness and to provide some capacity for attorneys and advocates who might be interested in providing legal representation for key and vulnerable populations who are impacted by discrimination and stigma related to their HIV and or TB status. This webinar is part of a larger project that that probono.org is carrying out with generous support from AIDS Foundation of South Africa, AFSA, and the Global Fund. And the overall aim of that project is to combat human rights abuses related to discrimination and stigma related to HIV and TB amongst key and vulnerable populations in South Africa. Within the ambit of that grant, we have conducted training of paralegals and support to community advice offices across 35 districts in South Africa. We're involved in awareness raising through partnerships and networks with other sub-recipient grantees of the Global Fund funding, Global Fund and AFSA funding. We're supporting possible impact litigation related to the same topic. So we're very excited, first of all, to be a part of this area of work, and our aim and goal is to ensure that we're able to use the pro bono model of recruiting private attorneys to provide pro bono legal services for those who are less fortunate in South Africa, the marginalized people of South Africa who otherwise would not have access to legal services. And so we're very happy to have Candice Pillay, as well as Nikki Stein, to give inputs during this webinar. So I just want to thank everyone for joining us, and I hope you find the time valuable. So thank you for joining us today.
Thank you, Teresa. Great work there from probono.org that they're doing. So I'd like to start with our first guest speaker. Candice is a pro bono lawyer at Lawtons Africa and runs a public interest litigation practice. She has a passion for teaching and informing people of their rights and remedies, and today she's going to share some insight into how lawyers can get more involved in HIV and AIDS litigation. Candice, if you'd like to share your presentation with us, and I give you the floor.
Thank you so much, Mark. I'm just going to start the slideshow, if everyone can see it. Yes, hi. So good morning, everyone. Yes, I'm Candice Pillay. I don't know if you can see my, if someone can just confirm. Great stuff. Okay, so my task today is to really talk about some of the experiences I've had and other lawyers have had just in the field of litigation when it comes to HIV and AIDS. And one of the things I'd like to share with you is just sort of an overview of some of the rights and remedies that are available to persons with HIV and AIDS. I'm going to look at some of the case law that have come up and some legislation that's going to help, and then look at some types of cases which legal practitioners can bring and get involved in. I'm not going to follow that structure. I'm just really going to speak about what I want to share with you today. So I'm just going to get right into it. I think we all need to be sensitive to the fact that we live in a society that continues to discriminate and practice stigma against people living with HIV and AIDS, and we live in a society where there's so many human rights violations that we just live with it, and very seldom do we actually realize that many of the discriminations we encounter on a day-to-day basis is actually actionable. And because I think I'm talking to a lot of people involved in the legal profession, just want to point you quickly into to our legal structure and framework. I mean, we have the three arms of government, and I'm reminding you of this because not all cases are cases that we need to take to court. So we have policy, we have the legislative that makes laws that can be challenged, and they have policies that we can go and challenge that. We can appeal decisions made. We can take decisions on review. We have our executive, who runs the country. And that's where our administrative law actually sits. And that's where we need to look at certain administrative decisions that are made that forms the basis of discrimination or unfairness when it comes to the client sitting in front of you and saying, this is what happened to me. And of course, the judiciary is just sort of the final forum where we can look for resolution of our disputes. And I think a lot of lawyers shy away from taking on HIV/AIDS cases because they think it sits in our judiciary, that it's going to be a long, drawn-out case and it's going to cost a lot of money, and it's either going to the Constitutional Court, or just in the High Court. But a number of the cases we've done actually just start off as comments made on policies that are put out by government or administrative decisions. So just a quick reminder there that it's not always a judicial case, a case that's taken to our courts. So one of the ways I start off with taking a case, and it's something important to realize, is people suffering with HIV and AIDS have all the same rights and legal remedies that everyone else has. There's nothing particularly specific to that. But there is a body of jurisprudence that has been developed that will assist people who have HIV and AIDS, and that is a factor in the legal case that they present to you as an attorney or as an advocate. And my starting point is identifying whether HIV or AIDS is part of this legal problem that they present to you. The first thing we do when we take instructions is we ask the question whether the client's HIV or AIDS status is a factor. Sometimes the person would just say, I've been evicted from my house, and it looks to you as an eviction matter. But then you probe and you ask the question, well, is there any other reason, or why did this happen? And they say, well, it was because I go to the hospital so many times a week. Oh, okay, why do you go to the hospital? It's because I have HIV and AIDS. Now you're getting somewhere, and you can say, okay, well, yes, it is a factor, but has it contributed to this, to the legal issue at hand? And that's the second inquiry I normally make, because if the person just goes to the hospital and that's not a factor, that's fine. But if it's contributed, then it's an actionable case. So it's not just an eviction, it may also be a discrimination case. So I'll give you a good example. A gentleman referred a matter to me, and he said that an educator had been taking a lot of time off from work, and then she was fired. And then he's like, why was she fired? And it's like, no, she was sick. And then you kept on digging. Eventually, it was that she had made a disclosure of her HIV status to the principal, and the principal decided that he was then going to breach her privacy and disclose that to the parents, and then the parents called for her to be suspended. And so therein comes the discrimination case because of the infringement of her privacy. So those are the kind of inquiries you have to make. And finally, you have to figure out, has a crime been committed or a right been violated? Because obviously rights-based litigation can be done pro bono, but then if a crime has been committed, and we'll talk about that just now, there are criminal remedies available. So then once you've identified the legal issue, you have to then decide, okay, what is my next step? And very often practitioners won't launch the case. And we often encourage community legal advisors to say, okay, refer the matter on, refer it to probono.org, refer it to the Human Rights Commission, or refer it to pro bono lawyers. And your starting case, for those who are in practice, is you start with a rights-based discussion. You say, which right has been violated? And there's a list of rights. I'm not going to go through it, but these are all the rights set out in the Bill of Rights. You're going to say, what right has been violated that I can take and make this actionable as a rights-based discrimination case or equality case or privacy case? Is it a freedom of expression? What right am I going to pin the legal case on? Okay, and our discrimination-based cases are always an add-on to something else. So yes, you have someone suspended from work, but there's an equality or a dignity argument to be made in every one of those cases. And think about your cases always like that. If your client comes in and it's an eviction, there is a very big dignity argument to be made for someone who is being evicted and is going to find himself homeless, someone who loses the job, their employment. It's the same thing. So always think about it, that equality and discrimination and dignity arguments are always turned with socioeconomic rights. So don't look at one to the exclusion of the other. And this is just to encourage you, as those legal practitioners joining us today or watching this, is that you don't have to look for an HIV/AIDS cases. The cases exist. You just have to make the inquiry. So one of the first cases that was taken on was the case of the Treatment Action Campaign versus the Minister of Health. And this was as early as 2002, where they challenged the minister for not actually taking action to provide ARVs to persons diagnosed with HIV and AIDS. And this brought about massive reform in our healthcare system. So the fact that the case was brought to court, a directive was actually given by the judiciary to the government to now start creating policy, start creating legislation, and to actually change how the Department of Health, the Ministry of Health dealt with patients, brought about mandatory counseling for all, medical testing facilities. So this is the kind of remedial action you're looking for, not just for the named plaintiff in the matter, but really for something that's going to have far-reaching effects. When we look at employment as well, there's huge strides in employment law. Those who are employment lawyers will know that the Basic Conditions of Employment Act and the Labor Relations Act now fully embrace and counter discrimination on the basis of HIV, AIDS, and HIV status. And one of the key cases that I love, sharing all the time is the case of Orpas versus Moycliffe in estates that said that a person who is HIV positive and is on ARVs and is still able to work, should be able to work, because there's no difference between someone who has a normal sort of like illness, a cold or flu, and someone who's on ARVs. It is their ability to work or their capacity to work. And so this was followed in a number of cases following that as well. We look at children. There's so much discrimination when it comes to HIV and AIDS in children. And really, colleagues, I'm really looking for a case that if anyone comes across where a child is involved, there's discrimination in terms of mandatory testing without the child's consent or the parents' consent. There's discrimination in terms of admission to high schools and primary schools and daycare facilities. So I haven't yet received a case like that, but you know, there are a lot of children living in children-headed households because their parents have died from HIV and AIDS. So those are the types of cases you want to be taking to court and looking for relief and looking for some kind of assistance, providing assistance on a pro bono basis because HIV and AIDS has impacted them. So we get a funny kind of HIV and AIDS coming in terms of divorce, because one partner is found to be HIV positive, and then clients come in and say, well, he's divorcing me because I'm HIV positive, he hasn't been tested, or vice versa. And so we always have to sort of negate the sort of the understanding or the common understanding of people about the grounds for divorce. And the test for divorce is irretrievable breakdown of marriage. And some spouses have tried to get an unfair advantage in terms of the division of property based on HIV and AIDS. And I think this is, if you've never had it, then great. But we do get it from time to time. And it's a good way to debunk some of those myths about HIV and AIDS and discrimination when it comes to marriages and divorces. We do social assistance has been amazing. Now you get disability for being HIV positive, but obviously you've got to be on medication. You've got to get letters from the hospital saying that, you know, this is your CD4 count is at a certain level, etc. But you do get a disability grant for social assistance. But where I feel that the lawyers can get more involved in is where, like I said, in terms of evictions, in terms of tenants who are HIV positive, or places where they refuse to rent a property because someone is HIV positive and they are aware of it. We look at a lot of private and public accommodation. Department of Housings, you know, you do hear stories where people say, well, the reason I applied for housing and I said I have a disability and I'm HIV positive and I wasn't given housing. Whether that's true or not, it's still a good case to be interrogated and taken to court. One of the decisions that came out on privacy was in the Irvin and Johnson case, where the INJ wanted to impose mandatory testing on all employees in their trawling division. And the court was very clear. The court said, yes, well, in that case, they lost because, you know, the way they did it was wrong. But they said that this is where it came out that an employer can impose mandatory testing if it is important or relevant to the job. You know, if they're in a high-risk area, of course, INJ, they're dealing with fish and blood and food, and so that it was relevant to have the testing done. But there are other sectors that actually don't need mandatory HIV testing, and this is things to look out for if it now becomes a precondition to employment. Obviously, our insurance industry has made great strides in providing insurance and benefits and packages to HIV positive persons. Of course, you know, the benefit is to the insurance industry, but every now and again, you would find that there are discrepancies in terms of the assessment criteria. So the risk ability, the risk profile for someone on ARVs as someone without HIV is exactly the same, but you would have to really find a case where someone would say, well, I tried to claim on this policy and I was told I'm not entitled to the same benefits because I'm HIV positive, or I disclosed, or I didn't make full disclosure. Those are the kind of technical insurance cases that it smacks of discrimination, but has the issue of HIV and AIDS linked to it, that's going to now assist the person to get there. And then finally, I was talking about criminal law earlier on. Criminal cases in terms of HIV and AIDS are very few, but you have hate speech, which is a hate crime, and if somebody starts making slurs about your HIV status, etc., etc. But we also have the crime of embarrassment, criminal injury, where you can literally say when somebody has gone and shouted at you, well, you're HIV positive, you got AIDS, or that sort of thing. There is criminal sanction against it. Of course, we have our Sexual Offences Act, but those are specific violations of a person's bodily integrity. And just very quickly, because I'm really at 15 minutes, some of the resource material, if you look at it, there's been a lovely development of the jurisprudence on HIV and AIDS, starting from our Bill of Rights, which sets out all the rights, then following the Treatment Action Campaign case, we've got the National Health Act, which sets the standard of the right to health, and then everything in the National Health Act is then actionable if the government or a health services provider falls short of that. You have a number. You have the Charter of Rights on AIDS and HIV. You have the Patients Charter. You have the National Policy on Testing for HIV. And the health professions guidelines, quite a few good policies there that you can really interrogate, and it gives you a guideline as to how to, when you got a case, it adds not just a case law or legislation, but really adds that kind of academic policy and material to your argument, that you can say, well, in addition to A, B, and C, this is also what we've had. And of course, I've thrown in the Sexual Offences Act because they've created some quite a few inroads in terms of perpetrators who are HIV positive and mandatory testing for them. So just be aware of that if you are a criminal defense lawyer, and those provisions will apply to some of your clients when it comes to sexual offences. So that brings me to the end of my presentation. It's just a quick overview, but I'm open to any questions. Thank you.
So thank you, Candice, for that wonderful presentation. I'm going to ask the questions in the Q&A sessions. And that would be straight after our next guest speaker, which is Nikki. We'll go over then to Nikki then, which Nikki Stein is a member of the advocates group 621. Prior to joining the bar, she worked as an attorney and then as an in-house counsel at Section 27, a public interest law center conducting research, advocacy, and litigation on the rights to health care services and basic education. Section 27, which was previously the AIDS Law Project, continues to work closely with the Treatment Action Campaign in advocating for the rights of people living with HIV. So with that, I hand over to Nikki. If you could share our presentation with us.
Thanks very much, Marco, and thank you so much for having me today, and to probono.org for arranging this really important event. It's almost 17 years since the beginning of the rollout of free antiretroviral treatment in the public sector. And that was the Treatment Action Campaign that Candice referred to earlier. And we have come a long way in the fight against HIV and the protection of people living with HIV. But what I'm going to talk to you about today is that I don't think that we have come far enough. I still think that there is a very long way to go. And so what I'm going to do at the outset is ask you all a question, and I'd like to get your answers, keep it in mind throughout my presentation, and I'd like to hear your answers during the Q&A session. And the question I have is this. Candice has taken us through quite expertly a developed and developing body of law around HIV, around the protection of people living with HIV. All of us are living and practicing law at a time where dismissal of an employee for reasons related to their HIV status is automatically unfair. We're in a time when medical aids are obliged to cover antiretroviral treatment in full without any co-payments or deductions, and regardless of the plan that you're on. We live in a time where HIV is a chronic disease, and it should not stop you from going where you want to go and doing what you wish. But my question to you is this. do these protections actually achieve their purpose in practice? Are the lives of people who are living with HIV actually improved? Are the people who live with HIV in a better position than where they were 30 years ago? And my proposed answer to you is no. Without more, these so-called protections do very little to actually improve the lives of people living with HIV. And to illustrate this, I'd like to talk to you briefly about 3 cases that I worked on while I was employed at Section 27. The first of these cases is the case of Miss M. Miss M was a domestic worker for a family in Johannesburg. At the time that she was employed, she knew that she was living with HIV, but she didn't disclose this to her employer because there was no reason to do so. A few years later, on the advice of her doctor, Miss M was initiated on treatment, and again, there was no need for her to tell her employer, and so she started taking her treatment and adjusted to doing so without them even noticing a difference. A few years later, the family she was working for decided to have another baby, and so they took a decision to employ a new domestic worker to assist Miss M in her duties. When this new employee was employed, the family forced both her and Miss M to go for HIV testing without their consent. Miss M obviously tested positive, having known for many years that she was living with HIV. Her employer found out for the first time and tried to send her home under the guise of ensuring that she had the space to adjust to her status and to adjust to her treatment. She saw what they were trying to do, and so she resisted being sent home because she knew that they would never take her back. They then realized that they couldn't just get rid of her, so they accused her of assaulting her colleague and threatened to dismiss her for that. She got an affidavit from her colleague to say, no assault, nothing of the sort ever happened. Miss M and I have a very good relationship. And so the family's response was to accuse Miss M of stealing a laptop and a tablet that had previously been gifted to her. But they were not going to let reasonableness prevail. When she attended her disciplinary hearing, armed with the evidence that she had not stolen these items, her employer forced her to undergo a polygraph. They then brought in 2 quite large and intimidating men to try to persuade her to resign in order to escape criminal charges. They went so far as to call the police, to have Miss M taken away in a police van in front of her child, and to threaten to hold her in custody over the weekend unless she resigned from her job immediately. And so left with no choice, Miss M resigned. Her employers had obviously heard somewhere that to dismiss Miss M because of her HIV status would be automatically unfair. But they went to great lengths to dismiss her anyway and to disguise the real reason for doing so. The second case I'd like to tell you about is the case of Mr. R. Mr. R is a journalist, and he decided to apply for a job overseas. He got a position with Al Jazeera, based in Qatar. When he arrived in Qatar, he too was subjected to an HIV test without his consent. He was immediately arrested and deported back to South Africa. It was only upon Mr. R's arrival back home that he discovered that he had tested positive for HIV and that he had been arrested and deported for that reason. Qatar, I learned, is one of a number of countries that does not under any circumstances let any person in if they are living with HIV. And so Al Jazeera, claiming to be the voice of the voiceless, did what was needed to ensure that Mr. R was removed from Qatar without any delay. Mr. R was therefore faced on his return with a new diagnosis of HIV, with having lost his job, and with the trauma of everything that he had been through in the process. The third case I'd like to tell you about is in some ways even less believable. It involves Miss H, who was the domestic worker of a very senior member of the legal profession. A member of the legal profession who had been trained in the laws prohibiting discrimination on the basis of HIV, and who is expected, as part of the oath that she has taken, to conduct herself in accordance with the rule of law and with the utmost ethics and integrity. When this person found out that her domestic worker was HIV positive, she put in a new system at home. Miss H was called in to compulsory weekly weigh-ins, during which her employer would monitor her weight. Her employer constantly questioned her about the food she was eating and would check that she was taking her medication like you would check a child. Although Miss H had for many years been looking after the employer's brother who had had a stroke, her employer prohibited her from continuing to do so. She wouldn't let her anywhere near him. And finally, her employer disclosed Miss H's HIV status to all and sundry. And she did so in order to illustrate to her friends what a tough time she was having and how virtuous she was in continuing to employ somebody living with HIV. She too forced Miss H to resign. In fact, what she did was that she locked the gate when Miss H was on her way home and refused to unlock the gate until Miss H signed a letter of resignation. So by the time these three clients approached Section 27 for assistance, and by the time that I, as the attorney, met with all of them for the first time, they had all gone through enormous trauma. They had all been betrayed by the people that they trusted and depended on, and by the people who knew the law, or definitely ought to have known the law, and yet breached it so blatantly anyway. And so it comes as no surprise that these three people, and the thousands of others who are in a similar position to them, are quite reluctant to trust anyone else, particularly a stranger who they've never met for the first time and is asking them incredibly personal questions about why they are there in their offices. I understand that most people on today's webinar are lawyers or legal practitioners in some sense. And as a fellow lawyer with a commercial background, I understand that we are all quite used to giving advice to people in the context of a relatively equal power dynamic, where we give advice on new tax provisions or on the validity of a sale of shares. We do so to people whose rights may have been breached. But, and I understand that I'm generalizing here, for the most part, the breach of those rights does not go to the core of our client's dignity. Where our clients have been on the receiving end of discrimination experienced, such as that experienced by Miss M, Mr. R, and Miss H, they are coming to us from a completely different context. Before they have even arrived at our offices, they've had it ingrained in them that they have done something wrong, that they deserve the treatment that they have received. And so what do we do about all of this as lawyers? And my first suggestion to you is quite a simple one. Take that case. I have the discussion quite regularly, and most recently I had it last Thursday night during drinks with a few colleagues. People say often, well, Nikki, I'm not sure what to do. I just don't know where to find these pro bono cases that you speak of. And Candice touched on this too. If you look for them, the cases are there. I truly, truly wish that we lived in a society where we all had to fight over pro bono cases and fight over clients who just want their day in court. Unfortunately, we don't. There is plenty of work to go around for all of us. All you need to do is just open yourself up and make yourself available for it. And that takes me to my second point, is that once that case lands on your desk, treat it as you would any other case that lands on your desk. There is simply no reason not to. In fact, there is even more reason to prioritize it over the other cases that are on your desk. Your client has already been failed. They have already been denied a voice. It has taken them a huge amount of courage to come forward and to seek your assistance. If we as lawyers treat them any differently than we would treat any of our other clients, then we are not only failing to address the problem, but we are perpetuating it. My third and final suggestion is this. There is an absolutely enormous network of lawyers, doctors, activists, judges, any type of person you can imagine that has developed a huge amount of knowledge and experience on cases of discrimination on the basis of HIV status and indeed TB status. These are people who are committed to providing support and assistance to people living with HIV, but they are also committed to providing support and assistance to other people who are providing support and assistance to people living with HIV. You don't have to reinvent the wheel in taking on these cases. You are not alone in your litigation. Tap into the knowledge and experience, draw from it, and contribute your own. And let's truly stand together to fight against this discrimination that we see 30 years, 40 years on. I believe it is, I think it's 42 years since the first World AIDS Day. So I'd like to leave you on that note. And I'm just, sorry, one more comment. And my final comment is this, that as a lawyer dealing with cases involving discrimination on the basis of HIV status, you're putting on a slightly different hat. You're not putting on the hat of somebody who drafts the papers, consults with clients, puts on a suit and goes to court necessarily. You're dealing with somebody who is a lot more vulnerable and who requires a lot more from you in building that trust relationship. And so be aware of that. Be aware of the fact that the law may not come to the assistance of your client in each and every aspect in which they need assistance. And be open to assisting your client to find those other sources of support in order to strengthen their courage, in order to strengthen their dignity, and in order to carry your case and the development of the law forward. Thank you.
Hi, thank you, Nikki. That was a strong statement at the end there, that we all need to really try our best and support these the persons that are that have HIV, AIDS, or TB, to help them and assist them. So we come to the Q&A section. So I've actually got a few questions, or I've got one particular question. It's around that Candice and Nikki brought up around carers and domestic workers. So I've got a scenario here where, let's say we've got an intersectional worker. So she's a foreigner. She does not have papers to work here in South Africa, but received a job to care for let's say a minor child. She didn't disclose that she had HIV or she was HIV positive, but later on she was assisted to do a test by the employer, which later showed she was positive and was fired for being HIV positive. What can for the person who was fired, like I said, she's a foreigner and she doesn't have working papers here. What can she do? And from a law point, what can lawyers assist her in? I give this question either to Candice or Nikki to answer, or both.
Candice, I'm not sure if you want to kick off.
Okay, sure. So, so we do get a lot of these questions, and it's a difficult one because we have some dubious jurisprudence that says that if someone is legally in the country, they're already committing a criminal offense, and then you can't perpetuate your rights, sort of the illegality of working. But we have taken matters forward at an unfair labor practice and an unfair labor. The fact that the person is employed, I'm not sure if it's just me, but there's a sound in the background, some interference. So in that case, yes, we would definitely submit a claim to the CCMA because they are employed, and then the Labour Relations Act does apply to them. We also look at especially with regard to domestic workers as well. I mean, some of the sector deliberations don't apply to them, but we have been successful on occasion with sort of non-South Africans who do not have permits in South Africa for an unfair dismissal. So I would suggest that if that's the given facts of the situation, they would be wise to, first of all, consult with a lawyer, or refer the matter to the CCMA first of all. If they have not done so, there is actually a pro bono office at the labor courts where there are labor employment lawyers that will assist them to then bring the case through.
Okay, interesting. So I've got a question in regards to how do we protect the client's privacy if they are afraid of stigma?
I'm happy to answer that. I think the kind of simple catch-all answer to it is that there are mechanisms, if you do take a case to court, there are mechanisms to protect the anonymity of the client. And so certainly in most cases that I've dealt with, you will either reach an agreement with your opposing party if they're reasonable, or you will seek an order of court allowing them to remain anonymous in the court papers that are made available to the public. It may be necessary to some degree for them to disclose certain personal facts that just are necessary for the opposing party to know what case they have to meet. And I know that I'm mentioning that because it is often quite an unrealistic expectation that, you know, for example, somebody who's employed by a big company who is dismissed because of their HIV status, the company will need to know who that employee is. The company does already know about that employee and their HIV status, but they will need to know certain facts to know what case they have to meet. And the court will, of course, need to know certain facts in order to adjudicate the matter properly. But it is a relatively easy process for that anonymity to be protected in relation to papers that are made available to the public. And in extreme circumstances, facts will be disclosed, for example, to an employer's or to the other party's legal representatives, but not to that other party themselves. It will all depend on the circumstances of each case.
I was going to add that generally when clients come to us, the privacy has already been violated. And so it's common cause that the plaintiff or the complainant, it's well known that the complainant has HIV and AIDS because of the violation of privacy there. But Nikki's quite right. You know, we can go, if you are bringing a case where specifically the sort of wider disclosure might be harmful to your complainant, then you would then have to ask the court permission not to disclose the identity, but only pertinent facts, and probably get some non-disclosure agreement going with your opponent or the respondent or the defendant that whatever is the violation of privacy sort of stops here and is not extended beyond the court case.
Thanks. Hi, I wanted to ask a follow-up question. What can an attorney or an advocate for that matter directly ask about the client's status? I mean, if they suspect that their client is HIV/AIDS positive or has TB, and that the discrimination that they're suffering from may be related to that status, but the client has not revealed it, can a legal practitioner, ask that information if it hasn't been volunteered?
So as an attorney, if it's fundamental to the case, that's why I said in the initial inquiry, when the client comes and gives you instructions, but sort of talks around the issue, generally, I would tell the client that if it is integral to the case itself, that their HIV status makes the case or breaks the case, then I would ask them that, because all communication between attorney and client is privileged anyway. I can't release the information once I know it without the client's permission. So even if I'm drafting papers, I would still need my client to consent me making the disclosure in the papers, but it's also important for me to understand the legal remedies. If it was just a sort of a violation of the right to dignity, but was not a privacy issue where disclosure of the HIV status was made, that's fine, it's not relevant. But I've had a case where I saw in the hospital records that the client was HIV positive, but the client had never disclosed that to me, and so I never asked. Obviously, at some point, I have to make discovery, and I have to discover the very same hospital records, which is required by law. But because the client never volunteered the information, and his HIV status was not relevant to the current claim, it was an insurance claim, but it was not pertinent to the claim, I never asked and he never volunteered. So I think for me, it would depend on relevance. If HIV/AIDS is the merits of the case, focusing around that, I think it's important for clients to disclose, and it's privileged. And once you disclose to your lawyer, you can then control the disclosure. The client can control the disclosure and say, well, you may not tell the other side, and that's fair, because then the lawyer knows how to handle the case going forward. If it's not relevant, then I don't think so.
Can I perhaps just add to that, that, I think that is such an integral part of developing that trust relationship with your client, because, you are meeting them for the first time. They are coming to you as vulnerable and traumatized. I had a client a few years ago. It was a case against a medical scheme who was refusing to cover her antiretroviral treatment. And so she'd been paying out of pocket and she couldn't afford to do so. And it took her many years to come to us with this problem. So many years, in fact, that part of her claim had unfortunately prescribed. But when she did come to us, and when we did agree to pursue part of her claim, the part of her claim that we could, we had a very long conversation about what it meant for her to disclose her status to us and who we could disclose to. And we came to a very specific agreement that I was not allowed to send her SMSs or WhatsApps or leave any voicemails on her phone, because she was so terrified that her family was going to pick up her phone. One of her kids would pick it up to play a game or something like that. And so we came to an arrangement that she would phone me every 2 weeks or so and ask if there was any progress on the case. And that was how we would hold our communications about the case going forward, in order to ensure that nobody around her status would not be disclosed to anybody around her. So it's imperfect, but there are ways of getting around that, and of reassuring your clients that really what they tell you, just like any other client, what they tell you remains with you. And it would, as Candice says, sometimes be in the best interests for them to disclose to you, but then you can both manage how to take it forward.
Yeah, thank you for that. We have another question here. Could you talk a bit about the gaps in law and policy that, if they were fixed, it would improve the protection of HIV positive persons?
So I found the anomaly in our law is that certain aspects of law are very well developed when it comes to HIV and AIDS, and other aspects not so much so. So having reference to the presentation that I made, when I look at employment law, it's almost a given, HIV, AIDS, there's so many protections there. And but when I look at the right to health and the right to health care, we have the Bill of Rights, and we have the National Health Act, and we have all the policies and the patient rights. And for me, the gap there is still the difference between what exists as law and the actual treatment received by patients who go there. So when I look at, like, for example, the National Health Act says that, you know, the right to health means accessibility, but in accessibility means so many things. There's got to be a health service provider in your area where it's accessible from the point of view, it's you can go to the nearest clinic, and there would be an HIV/AIDS division there that will provide you with ARVs, and that's one kind of access. But there's got to be home care, you know, there's got to be an outreach program where if people are unable to go to a hospital, you know, does the right to health guarantee that nurses will come and check in on you at your home and give you the necessary medication. That's accessibility. You know, accessibility also means affordability. Now I know our public health system is great because you're not paying that much, and most medical aids cover ARVs, but you know, it's still, like, for non-South Africans, you know, it's still a huge hassle for them to access ARVs in our provincial hospitals. So these kind of gaps, when we look, for me, especially with the right to health, and that's where policy needs to step in and create and fill that gap. You know, also with privacy, when I did some other training, people were saying that you walk into a hospital and you have to announce at the front desk or at the reception that you're there for ARVs, you know, and then somebody shouts across the room to the sister to say, this person's coming for ARV, and then you want to whisper to them that the patient is entitled to dignity and to protection of their privacy, and you really shouldn't be shouting or having, you know, pink files for ARV patients. Those are subtle things that you find that literally when you're trying to access these rights, everybody knows, the nurses know, they talk about it, and are the people who should be protecting the rights at that very basic level, do they actually know what it means to protect their dignity and the privacy of someone else? So, I mean, I can talk the whole day about this. I'm going to stop there. So just for me on how the right to health is actually delivered and accessed by sort of the average user of our healthcare facilities. There's a gap between a very good Bill of Rights and a very good right and a very good National Health Act, and actually the delivery of medical services to people who need it.
I was actually about to say the same thing as Candice, just in relation to what happens in hospitals. I worked a few years ago in a case involving the closure of a health center on the border between Limpopo and Mpumalanga. And they had this incredible program. And when we interviewed patients, what was happening was that the Department of Health wanted to close the facility and to make all of the patients go into public facilities. And when we interviewed patients about the impact that this would have, they spoke, some of them almost solely, about the fact that what was so wonderful about the center was that everybody had the same color sticker on their files for what they needed, and everybody queued in the same place for their treatment. There was the same pharmacy, and everybody was subject to the same treatment. And in fact, a lot of them said that if the facility was closed, which it unfortunately ultimately was, that they would not go to a public healthcare facility for their treatment because they just didn't want their status to be disclosed. And so we're getting a lot of defaulting on treatment because of that. And, you know, I think there, Alice, the law and policy are for the most part great. But the problem is the stigma that still exists. You know, we still whisper HIV like we whisper cancer, and we whisper, you know, all of those things that we don't want to put out into the universe. And there are so many people that still don't understand that it's a chronic disease. If I wear my HIV positive t-shirt, you know, I have a whole collection of them. If I wear my HIV positive t-shirt to the gym, I know that I will have first choice of any machine or any weight or anything that I want to use. And that's where the problem is. As nice as it is going to gym and, you know, not that is where the massive problem is that we still believe things that are simply not true. Our thinking is 40 years old and it hasn't caught up, and we're not actually calling each other to account and saying to each other, hey, it doesn't matter. I also could carry on for hours, but I think the bottom line is that we need to have conversations about stigma, and we need to start educating ourselves and each other, and doing away with our discrimination that is not supported by law and policy.
Okay, I'm just looking at the time. We've got 5 more minutes left, so I don't think we've got time for any more questions. If I do receive any other questions and all that, I will, if it's all right with Candice and Nikki, I'll forward them on to you via email, and I'll post it in the comment section, the answers, once this recording of this webinar is available, so people can then see what was asked and what answers were given. I would like to just quickly hand over to Alice to give us a vote of thanks. Alice?
Great. No, thank you, Nikki and Candice. This has been quite informative. Thank you so much for taking the time out of your very busy schedules to participate and to share your knowledge and expertise. And we also appreciate generally the work that both of you do and your commitment to pro bono and public interest law, and generally making access to justice real for so many people. So thank you on this World AIDS Day for your contributions, not only just now, but more broadly over the years in which you both have been practicing law. Thanks very much. And thank you, Marco, for being a great host and a great IT facilitator, because rest assured, I'm a dinosaur. So I would not have been able to help out on that front. So thank you.
Yes, I would also want to say thank you to Nikki and Candice for all the work you guys do. It's something amazing what you guys do, and I hope this message is pushed out to all the other legal practitioners that want to work on a pro bono basis and help those people that are in need, not just with HIV, but in general, just that require legal services. So thank you. I just have a quick section that I want to show you in regards to where you can get resources on the probono.org website. So if you go into your web browser and put in probono.org.za, you'll get into the home page here, where we can then see there's a little video that was created to commemorate as well World AIDS Day. So please click on that and have a look on that. But what I wanted to show you here is more under media and under resources. Alternatively, you can type in probono.org.za/resources. And then we've got an HIV tab over here, and you as a legal practitioner will be able to get various cases and guides in regards to HIV, AIDS, and TB. So please visit the site, have a look through there. Maybe this can help you with your work and your matters. I mean, there's also other things involved here with family law, consumer law, etc., which you can also please feel free to look through to help you out. I mean, we all know we're going through this pandemic of COVID-19. So there's also some resources that are available in regards to COVID-19 and health matters in general, HIV. So please, there's some online articles available for you to read, and also certain guides in terms of rights, human rights, and the impact of COVID-19. So that's is all from our webinar today. Again, thank you to all our guest speakers and to Alice and Teresa for being available and to share your thoughts. I thank you again to all the viewers there that are watching on YouTube live. I will be sending out again a link once a recording of this will be available on the probono.org site and also on the YouTube channel. So thank you so much, and please take care and enjoy the rest of your day.
Okay,
Thanks
thank
very
you,
much.
Marco. Thanks, everyone.
Thank you.
Bye, everyone.